Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to Surviving the Survivor. It is the show that brings you the very best guests in all of true crime on trending criminal cases. And we were planning to do Diddy tonight, but you know what? We're mixing it up because we got a lot of requests for this particular story, and that is of Sade Robinson. If you don't know her, 19 years old, Milwaukee resident, goes on a first date with a guy named Maxwell Anderson, and she winds up very tragically dismembered. Her body parts kind of scattered around Milwaukee and in Lake Michigan. Now, opening statements were delivered in the case today in Milwaukee, and they were really nothing short of both disturbing, shocking, pick your adjective. Prosecutors revealing for the very first time that Sade Robinson was intentionally decapitated. We knew that she was dismembered. We never knew the circumstances. Today they say it was basically a surgically precise dismemberment. So tough to hear and a brutal case. Nonetheless, those are the facts given to us. And photos found on Maxwell Anderson's phone show Sade face down on his couch just hours before she vanished. The defense saying, look, there's no DNA, there's no weapon, there's no motive. How could you find our client guilty? They said, you cannot prove this beyond a reasonable doubt. We're breaking down the testimony first, the best guests, and they are good ones. A man who knows a thing or two about homicides, not because he's ever committed them or ever will, but this guy was a homicide prosecutor in the greater Orlando area, and now he works for the defense firm of Mark Najim, who is a very well-known criminal defense attorney in the Orlando area, as is Ryan Vescio. And I think it was almost an STS single situation where Mark and Ryan met happily here, and neither of their wives are jealous. They're both happy. Next into the fray, Melba Pearson, the professor. She's a professor at FIU, Florida International University. She is a native New Yorker. She is very smart. She is also an attorney, and she will help break this down as well. And last but not least, John Tompkins, a criminal defense attorney in Indianapolis, who looks like a bit of an angel because he's got a halo around him. The sun is descending. Soon you will be able to see him. I promise you, he's not driving. He's in the back of his car with a stable transmission here, I hope. So we will see how that plays out as we go. So let's dive right into this. We're having some technical glitches all around. The COE is going to try to load up some video in a moment. We've got some clips of the opening statements, which were delivered today. Right off the bat, people aren't that familiar, but we are willing to go the extra mile at STS. So if you want us, this trial is expected to last through next week. And if you want us today, obviously we're opening statements and we're still focused on Diddy, which we're still focused on now. However, if you want us to stream this trial, let us know. I don't know. She is a beautiful woman, and this is a horrific crime. This, by the way, is one of the most highly publicized cases ever to come out of Milwaukee. Correct me if I'm wrong, but I think Jeffrey Dahmer was from the Milwaukee area. That obviously a bit more infamous than this, but this in recent years, this I'm reading the COE's message. This in recent years is garnering a lot of attention. So Ryan Vescio, we're going to get into openings and all that in just a moment. But first, let me just throw this out at you. This is a case where there is very limited, if any, sort of DNA evidence linking the defendant here. And you don't have, this is difficult what I'm about to say. They've never recovered the head of Sade Robinson. So this is a very difficult case with potential openings for the defense here because of sort of the lack of blood evidence, quite frankly, and DNA evidence from inside his apartment specifically, which is where they think that this may have all gone down. How do you play this if you're both sides? I mean, the prosecutors basically implored the jurors here to use quote unquote common sense, and the defense is saying there's not enough evidence.
Yeah. So first of all, good evening. The concept of common sense, lawyers love to use this. It's in most reasonable doubt instructions. The reality of it is common sense doesn't have a lot to play with jurors because they don't have experience in these types of cases. And if you're on the state here, what you're wanting to do is you're wanting to put together a web. Every single little fact becomes a link in a chain. And hopefully that chain stretches long enough to be able to prove guilt. Now, on the defense side, you're just hammering. Body wasn't there. We're not sure exactly how she passed. The lack of eyewitnesses. Surely if somebody was brutalized in this manner, surely, ladies and gentlemen of the jury, there'd be DNA all over everywhere, all over the walls and ceilings and the rugs and the this and the that. And this is an instance where most people in the public, their obsession and focus with crime and crime stories and crime movies could help the defense because most jurors realize that there is DNA in every case, that there are eyewitnesses and videos in every case. And the reality is those cases oftentimes are few and far between when they get to trial because all those other cases tend to plea.
Yeah. That great points that you bring up. Melba, to you, and then I promise we'll get it. A lot of people don't know this story at all, so I'm going to break it down for us in a minute. But Melba, obviously the recent massive story is Bryan Kohberger, and this reminds me in an odd way of that. This is a horrific murder where today in court, again, in their opening statements, the state laid out their case, and they said that this was an intentional decapitation, an intentional dismemberment, surgically done. They're obviously going to bring up, medical examiner to speak to all of this, the way body parts were found and things of that nature. And it was presumed to have happened in Max Anderson's apartment. I think it's on the south side of Milwaukee. But there is no evidence there. There was, as far as I know, no blood evidence, no DNA evidence linking him to that crime. And that's the same thing that we hear with Bryan Kohberger. And when that does happen, to Ryan's point, there are many, many people out there who actually believe that Bryan Kohberger is innocent. Now, the difference or the similarities between both cases is the digital forensic evidence is very damning. So that's going to be, I assume, what the state really has to play up here.
Absolutely. And hey, everyone, always great to be on with STS Nation. But this case is one that I actually followed and reported on when it initially happened. And while there may not be a ton of DNA evidence, what we have is the electronic evidence. So first off, you have the evidence of witnesses that saw the two of them out on a date together. So we know that her friends were like, she was going to go on a date with this guy. The servers at that particular restaurant affirmed that the two of them were together and that they left together. And her phone stopped pinging in his house. So if her phone stopped pinging there, he seems to be the last person to see her alive. Her phone stopped pinging, if I'm not mistaken, around 1 a.m., something like that, and she was never seen again. That's where the use your common sense kind of kicks in, because she was alive up until about 11 midnight, wherever, where they left together. Her phone stopped pinging there, and no one saw her again. What do you think happened? Was she kidnapped by Martians? Probably not. And also the way that I hate this, the way her body parts were just strewn across various parts of Milwaukee is, again, absolutely disgusting. But again, there's still probably more evidence in terms of, maybe where his cell phone was pinging and things to kind of, if I'm remembering correctly, I didn't refresh my recollection on the facts, for this, unfortunately, but I believe there was some evidence that indicated he was in some of the areas where the body parts were recovered.
Yeah.
So again, common sense, like, listen, you don't have to be a Rhodes Scholar, a legal scholar, whatever, to put 2 and 2 together and make 4. And if she was alive here and then her body's found over there, nobody's seen her in between, common sense says he did it, especially in the absence of any reasonable theory, which is what the defense would have to come up with. Like, hey, it wasn't him, but she had an ex-boyfriend, or, something else to stand in the gap of what happened. They don't have to, let's be clear. But if you want to succeed, you better give a bogeyman, whatever, to the jury for them to latch on to.
Yeah. So he had told a previous girlfriend that this was the beach where her parts of her body washed up, which was different. Allegedly, he sets the car on fire in a different part of Milwaukee, but apparently dismembers or gets rid of the dismembered body parts at an area where there's a kind of a secluded beach. And one of his previous girlfriends testifies to the fact that at one point, he either took her there or told her about that. She will testify, but she told this to police when they were investigating. Lisa Hummer here. I never stop getting shocked over these events. I mean, John Tompkins, you're a criminal defense out of Indianapolis, not that far away. Do you ever say to yourself, wow, we live in a sick world? Or are you immune to this by now yourself, having, not only defended clients for so long, just being in this world? This one is particularly disturbing because of the way the crime was committed here.
Well, I mean, I try to remind myself that nobody ever walks into a criminal defense attorney's office and says, I'm having a great day. And so we see kind of a skewed group of people at work, and you've got to get out and socialize in other places so you don't think that that's the whole world.
That's like the news business. No one ever gave me that advice, but now I will heed it. Go ahead. No wonder I'm so screwed up.
One of the things that really jumped out at me, and I do think there was a location on her phone going to the park after they left the apartment. But that was from an app, a share location app, not from her actual phone, I guess. Mm-hmm. One thing that stood out to me when they were talking about how this was a precision decapitation was that's a skill. That's not something that the average person, like, you don't learn that in high school biology with frogs. I would latch onto that as the defense. I would be looking for similar offenses. I would be looking for people with that skill in the area. I would be concentrating on, did they even look for anyone else? Did they run flock cameras to see if there were matching license plates, in addition to one surveillance video that had him in the area where the car was found burning? I would be looking for some other connection. But if there's not a connection, if you can't put that other narrative together for the jury, you look at those kinds of things and say, where's the evidence that he could even do this? Because, and you really prepare an excellent cross for the medical examiner and how skilled it was and how much training the medical examiner had to be able to do that type of dismemberment. And has he ever seen that before? And just how rare that is, and how there's no evidence that he would even be able to perform that act. If that's what they're going to focus on in their opening, you try to take it away in some way.
Yeah. All right. So let me just kind of let everyone in on this story, because a lot of people don't know about it. So obviously the victim, we've mentioned her name a bunch of times, and we should continue to do that. It is Sade Robinson. She is 19, was 19 when her life was savagely taken from her. And there we go. That's her there. Obviously a pretty young woman. She is a student almost ready to graduate Milwaukee area technical college. That is the actual name, I believe, of the school. She was pursuing an associate's degree in criminal justice. That's interesting. She was 1 month away from graduation, and she had a job, which she was always, prompt for and on, was diligent about. She worked at a place called Pizza Shuttle in Milwaukee. I remember delivering pizzas in college, and she was working in a pizza shop herself. Now, Max Anderson, who it's interesting, the state refers to as Maxwell, and the defense calls him Max. He is 34 years old. He has a prior criminal history. He is charged in this case with first-degree intentional homicide, mutilation of a corpse, hiding a corpse, and arson. Her Honda Civic was set on fire. Now, the crime goes back to the dates of April 1st into April 2nd of 2024. So it was really just a year ago. He's arrested, Max Anderson is, just 2 days later on April 3rd, 1 day later if you're counting the second. The jury on this trial, by the way, is a jury of 12 women, 3 men, including 3 alternates, so skewed heavily on the female side. Let me stop it right there. Ryan Vesio, in a case like this, and I'll go back to the night of the crime again. Who are you angling for in your old world as a homicide prosecutor? Who do you want on this jury, which is now made up of 12 women and 3 men?
You know, my rule of thumb used to be I want 1 or 2 more strong-willed personalities that I think will be able to control a jury room. Most of the people that I want are just followers. I don't want people that are overly excited, that, you know, did a backflip when they got their juror summons, because those people sometimes will want to read too much into things. I also don't want people who don't want to be there, because in the same sense, they're not going to pay attention. And on a case like this, the little details matter. To me, I think a wide representative of backgrounds is great. In a technical case like this, I think you walk a very fine line with people with technical backgrounds, engineering backgrounds, computer backgrounds. I would stay 100 miles away from lawyers or anybody associated with the legal field and HR fields and those types of people. The other type of person that I would want on this type of jury as a prosecutor is a female that is young, or a female that is involved in social work, teaching, those sorts of professions, that have contact with people like Sade. Because if a jury's going back and forth, there is a lot of implicit bias that applies, I think, on both sides of these types of cases, and that could help a prosecution here.
Oh, look at this, A Beautiful Uncurated Life. What a name. Wow. This story is close to home. She was found in a park not too far from me. Prayers go out to the Robinsons. Yeah, this has really been a big story in the Milwaukee area. It's dubbed the first date murder, and this was a first date. Melba, I'm going to come to you, but John, you're actively in a courtroom practicing criminal defense, and to Ryan's prosecution take on a jury, who do you want as a defense attorney representing Max Anderson? Who do you want on this case?
Well, I would want young men, single young men. Very consistently with Ryan, I'm looking for the opposite. I shy away from empathetic jobs, people who will naturally, even subconsciously, so maybe they can honestly tell you in jury selection, no, they won't pick a side, they won't vote with sympathy or bias, but nurses, teachers, people who are trying to help others and be very empathetic. This is a very sympathetic case for the victim, and there's no getting around how that victim was treated. You've got to get a jury that's going to focus on how did it happen, and could this person have done that? Because again, I think from what we see and what, there's a little history. This guy has an anger issue. He's lost his temper with relatives. And so that would be inconsistent with a precise dismemberment. And again, you've got a 2-day investigation before he's arrested. Did they even look for anyone else? And so you want somebody who is going to want that kind of precision, fill in those blanks filled in. And empathy does not go to a strict, did they answer this question? Did they answer that question? And what you're trying to do in the defense is get people who hear that question and will commit to wanting some of those answers. And those are engineers, accountants, precision type work, not empathy, support, social support type work.
Well, and Joel, one other thing, and I'm interested in John's thoughts on this because I'm going back and forth in my own head, and that is somebody in the medical field. Because I think John brought up a great point about precision and skill. I was involved in some death penalty appeal items here in Central Florida over a homicide that was a decapitation. And it's horrible. It is gruesome. It is graphic. Absent, chainsaws and all of that, it is very technical. And I think a medical person on this jury could potentially go one way or the other, but it would probably help the defense.
I agree. And great minds think alike, Ryan, because I was actually going to bring that up and say, would you want like potentially a surgeon on this jury? Because they're going to say, I went to medical school and then I did a residency and then I did this and then I did a fellowship and then I did that. And it's not that easy to do this. And I know firsthand. So interesting. I don't know the occupations of the jurors. I just know, as I said, I believe it is 12 women and 3 men. I feel like I hear a bomb ticking in the background. Is there someone else hearing that little beeping? I hope we're all...
I can hear it all.
I hear it too.
I heard that.
Your time's limited.
Dude.
Yeah. Yeah.
Cut the red wire.
That's what that's yeah.
No, the blue one. No.
COE. If you can figure that out, let me know. But I took my daughter. I love how original Hollywood is. I took her to see Mission Impossible 97 this weekend. And every trailer was for, the 30th sequel of whatever movie it was, which I guess would be more than a sequel. But anyway, I digress. So, Melba, to you, I closely watch both the opening statements for the the government, and then for the defense here. And first of all, the defense was really short. I think it was about 20 minutes, and the government's opening was maybe 45 minutes. And I'll be honest, they both had me kind of snoozing. And I feel like there is, and prosecutors generally, obviously, they lay out the facts more, and Ryan can speak to this. But I really do feel like, Tim Jansen says this, and a lot of people say it, that court is theater and it's storytelling, and you've got to sway these jurors. And I feel like that is just completely missing from both sides here. I don't know if it's just because, I'm in like the news business and you got to sell a story. I have no idea what it is, but how important is this for, especially for a defense attorney? He just had a very flat affect, almost like, I don't know, like and apparently he's a high profile guy who defended the so-called Slender Man defendant. But yeah, how important is style here versus substance in a courtroom?
So listen, I'm a former homicide prosecutor. I was all about style and substance, right? And that's something that I had trained young prosecutors on. Find your own style. Don't imitate someone else just because, oh yeah, I saw, whoever, Brian Steele do whatever. I'm going to imitate that because if it's not you, it's not authentic. But I've also seen prosecutors and defense attorneys who, talking to them is like reading the yellow pages, like you're just snoozing, but they're still effective. Somehow they sway jurors and jurors love them. I don't know what it is. So again, the key is making sure to connect with the jury in terms of, first of all, in opening statements, under promise, over deliver. Because if you say too much in openings and it doesn't come out in the evidence, the jury's going to remember it and hold it against you. So it's always better to keep it bare bones, stripped down, and let the evidence speak for itself. But then you really bring the funk when it comes to closing, so that you're bringing all the different aspects together for the jury to understand and refreshing their recollection. Remember day one of the trial 2 weeks ago when so-and-so testified. You have to remind them of that. But I think that the style is important and they have time to come back with it. Of course, you never get a second chance at a first impression. So, again, if the jury's looking at you and they're snoozing already, you're going to have to work a little harder to bring them back. But again, as a prosecutor, if your evidence is strong, if you've got interesting witnesses who are going to be able to teach a masterclass on cell towers and how things ping and, it's sort of like the inner workings of things, you may be able to bring the jury back that way. So style is important, but is it fatal if you don't have great style? Not necessarily, as long as you have strong evidence.
Good point. Well taken. Okay, so the evening of this crime. So it's April 1st, 2024. Sade Robinson finishes her shift at Pizza Shuttle. That's the name of the restaurant. Around 5:15 that day, she goes and meets this guy, Max Anderson, at a restaurant called Twisted Fisherman. A few moments later, they're having drinks at Duke's on the Water, so they head over there. 9:24 on that day, they head back to Max Anderson's residence, which is on 39th Street on the south side of Milwaukee. Surveillance video shows activity inside and outside Anderson's home till 12:45 a.m. So there's actually a camera that shows silhouettes and people moving around in that unit. But on April 2nd now, early in the morning at 12:45 a.m., so this is technically the next day, Sade Robinson's phone moves from his residence and it starts tracking across Milwaukee. It makes stops in downtown, then an area called River West, and then near the Milwaukee River. Around 5:30 p.m., this is now the next after this same day, but later that afternoon, much later, more than 12 hours later, a severed leg is found at a place called Warnemont Park by two people who are just walking by. The gate, interestingly, to the pump house at this park is smashed open, and the car, they do forensic testing there, and the gate is smashed open by what else? A Honda Civic that matches Sade Robinson. So whoever was behind the wheel of her car at that time, and one of the only people who likely had access, as far as we know, is Max Anderson. He broke open the gate at this park by smashing through it. Later on, in a different area of town, the Honda Civic is now found completely torched. And the very next day, I think to Ryan and or John Tompkins' point, he is arrested. So this arrest comes with basically within 48 hours. So Ryan, back to you. That is definitely going to be something that the defense latches onto here. But how do you counter it as a prosecutor? They're going to say, look, tunnel vision, tunnel vision, tunnel vision. This guy greets her via text messages on his cell phone. She comes over to his house, and within, a matter of hours, she's gone. And within a matter of more hours, her body parts are washing up. It's got to be this guy.
Yeah, and unfortunately, I didn't get to see the openings, but what these facts tell me is that there's more to the story. Mm-hmm. So I know a lot was made about an intentional killing, a decapitation, a dismemberment. Okay, back to common sense that those things just don't all happen as accident. The fact that her vehicle's being used to break through a gate is largely indicative of the fact that she's not driving the vehicle at that period of time. The vehicle's at the residence. And then now all of a sudden she's going on this path with her phone. What it tells me is that it is a sophisticated crime. And oftentimes it may not have been the actual homicide that was sophisticated, but the cover-up afterwards, which clearly is indicating consciousness of guilt type evidence, which could be important depending upon what the defense wants to do about who Max is, what his background is, what his troubles are. If I'm a prosecutor and I have a case like this, and I have somebody who's full of anger, I'm arguing it's a rage killing. I'm arguing that a reasonable inference is whatever happened to Sade was so horrible and horrific that her killer, the guy sitting at the other table, wanted to make sure that nobody could ever discover the depths of what she went through that night. So these types of crimes go to a much more, to me, place of almost mental health or lack thereof. We unfortunately see homicides all the time, But in a situation to where you have two people who don't know each other well, to go through this level of action after the incident really shows just a whole nother level of a deprived mind that will probably be an aspect of the trial.
Yeah. Well, one thing I'm very curious about is his social media and internet browsing history.
Yeah,
because
that came up today.
Yeah. I will pause and hear what you have to say.
No, I'll tell you. So the defense brought that up in openings. I'm going to play a clip in a minute, but he did no Google. There was nothing on his search history, nothing related to how to dismember a body, nothing on, how to drug or kill it. There's absolutely nothing. And then the defense went on to say, look, he didn't even delete his messages. They're on there saying, hey, let's meet at this restaurant. He made no attempt to hide an identity. But a lot of time, this guy, if he is the person that did this and the digital forensic evidence points to that, this guy was on track, if not already, to maybe being a serial killer. This guy was doing things sort of next level. So maybe he had planned it out in some other way or researched it in some other way. But yes, absolutely nothing in his search history in terms of those digital forensics that came up showing that he was trying to get information about how to do any of this.
Well, in one thing to that, Joel, on the digital forensics side, on his, I'd be fascinated to see where his phone is. Obviously, if his phone's in the same location as her phone at 1 a.m., 2 a.m., 5 a.m., 6 a.m., it's an extremely strong piece of evidence. Likewise, what I would want to look at here is I want to see what's the pattern of his phone usage the 2 and 3 months leading up to this. Because if I have somebody who 5 days a week is on their phone till 3 and 4 in the morning, no matter if they're on TikTok or reading articles or playing Candy Crush or whatever, if their phone's connected to a network and then magically at 2 a.m. on the night of her disappearance, his phone's now off network, that tells me that something's up there. So a lot of times cases are about evidence, but in these types of situations, cases can be just as much about a lack of evidence or a difference in pattern or activity from what the norm is.
Yeah, Melba, I know you want. Let Melba jump in because you wanted to go, and then John.
Yeah, sorry about that. But I think also, too, what would be interesting to see if there were any text messages to her afterwards. So one would think if you had a halfway decent date or a quarter-way decent date, you text, hey, did you get home okay? Or great seeing you. When could we link up again? Whatever. The next day, hey, girl, blah, 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 something, that there'd be some indication that acknowledgement you were together, or even, yeah, that was cool, but I don't think we should see each other again. I think some interaction would be very telling as well. But also, I will say that, like to your point, Joel, he could have been fascinated by death and dismemberment, and maybe he didn't necessarily Google it, but maybe it was something he fantasized about, maybe the types of movies he watched. If you watched a lot of very gory movies and decided to maybe, and I hate to say this, really gross, but a lot of serial killers start with animals first. So was he practicing in other ways that we're not aware of and then perfected the craft? Unlike, because we're all thinking, oh, you must be a surgeon, you must be a butcher to be able to do this with such precision. Maybe you're just really off and you've been practicing this for a minute and we just don't know.
100%. Tiff Knox, by the way, asked a great question. How far back was the driver's seat? Which I'm sure I hope they measured that and see if it lines up with his height. Maybe that's going to come into the testimony here. Dana C in the chat earlier, and I had read this myself, that there was some blood found in the basement stairwell, but that did not belong to Sade Robinson, which is curious because then you got to ask yourself, who does that blood belong to? Was this guy up to no good and just never got caught maybe until now? And by the way, this is a duplex, and we're going to hear testimony, I believe, from the upstairs neighbor who's going to say, I didn't hear a thing. So John Tompkins, that came up in the defense opening. Right. And how hard do you lean on that? You say, look, this guy not only is a neighbor, but it is a neighbor basically in the same residence just above them that heard absolutely nothing. The state's probably going to say, well, maybe she was drugged, but as a defense attorney, you're going to latch on to that.
Well, yeah, I mean, absolutely. But there are a lot of things to latch on to. First of all, he takes her on a date to a place where he worked, where he knows there are going to be witnesses who know who he is because he's there to get a form. So not only is he going to a place where he's worked in the past and the staff will know him, but he is actually on an errand to pick up a form from someone there who does that if they're planning a killing later. Then they have him allegedly driving all the way across town. Well, how does he get home? Somebody has to plan.
Bus.
Yeah.
No, seriously. He took a bus home. That's how he did. Apparently there's surveillance video on the bus of him
that shows him on the bus.
Yeah, apparently, yeah.
That's something that is going to be critical to the prosecution. I mean, the prosecution,
and it fits the timeline. Yeah.
Well, and that should have been my opinion. And prosecutors make their arguments however they want. That should have been the first thing they said. Yeah, I mean because that is an absolute inescapable fact. It's even if they don't have you at the scene, if they have you out of your apartment, coming from the area, knowing that you need transportation because the car only went one way, I think that should have been their opening statement almost in its entirety.
Ryan Vesio, what do you say about that? Because it came up in passing, I think, towards the end. But what do you think of that? Is that a much bigger deal that he's seen on? I don't know if something catches him either it's on the bus or coming off the bus in the very early morning hours of April 2nd. So
it's powerful because the picture you have up on the screen, if it were me, I'm putting the picture up on the screen. I'm putting him up off the bus, and I'm putting a map of between where the car was and where he is on that bus, and telling this as a story of before and after. This is what it looks like earlier on in the night. He meets this, young, attractive woman. They're at a bar. They're having drinks, and now all of a sudden, hours later, he's completely on the other side of town, close in proximity to her car that's been torched to cover up evidence, because why else do you burn a car, especially after it's been used to be rammed through a gate at a park where a body part comes into play?
And Joel, I'll pick up that thread from the defense perspective. The prosecutor, by focusing on that, forces the defense to answer a question they can't answer. You're behind from opening statement because you can't answer that question.
How do you? I mean, they're gonna answer it. They're gonna say something, right? Or they're gonna say that wasn't him. It looked like him, right? I mean, John, how do you? I mean, let me ask you this: how do you tackle that? So you hear openings, you hear this. What are you doing as a defense attorney?
Well, beforehand that's coming. It's been in discovery. You've talked to your client. What were you doing that day? Why were you out then? Every juror knows that after a date, you go to bed, you stay home. You don't go out on another date. Yes. What activity?
I'm sorry, John. By the way, not to interrupt, but I know I am, so I shouldn't say not to interrupt because I am. But there are two witnesses that see him setting the car on fire. So I mean, that's another big problem. That's another, but it's at night. And they claim that he's wearing similar clothing. No one ever gets a real good look at him, but there's a lot of coincidences. Let's put it that way.
Right. And those witnesses who see the car being set on fire, you depose them, you find out what did they really see? What's being characterized by the phrase saw him? Mm-hmm. They saw a man matching his description. They saw a person. They don't even know if it's a man matching the description. Was there a hood on? And then those are the clothes that you want to try to figure out whether they match the person on the bus. And if you can say, well, these people couldn't identify, and you can't from any video identify the person lighting the car on fire, they're just assuming this guy on the bus because he's wearing the same clothes. And if that bus video isn't clear, you might be able to weaken that. But if there's good video that's reliable face of him getting off the bus, you've got to find a way to explain why he's not in his apartment after that date and what he's doing on the other side of town.
And I'm gonna bet that bus video is very clear. If it's one of those that's inside of the bus, because usually that's used to protect the driver.
Right.
If there's a lawsuit or anything like that, they know it's going to be used as evidence. So the bus companies are going to get a pretty decent system. It won't be like, cases that I tried, like with gas station robberies, where it's so far you can't tell if it's a Martian, if it's a man, it's a woman, you don't know, but you're like, here. Yeah, this is going to be some good video.
By the way,
Joel, I think I can fix my camera, so I'm going to turn it off and reposition.
Okay,
stay on audio.
I'm gonna I'll just do that and I'll bring you back. Right? Oh, he's doing it now, so nothing I need to do. Melba, let me just go back to this about style, because when you're in broadcast news, you're taught to do things a certain way and be conversational. And I'm going to play a segment in just a second. But how important are first impressions? You go on a date, very important. But how important are first impressions for the prosecution and the defense when they are delivering their opening statements?
I think it's important because jurors are, I hate to say this, they're almost kind of bored in a way, right? They're sitting here, they're waiting for the entertainment. So what's the show? What you got for me, right? And if the first impression is like you're not organized, or you're boring, or you're rambling, things like that, the jury's going to get bored and get turned off. And even worse, when they're at lunch, when they're in the jury room, they'll be making fun of both parties. That's apparently what they do. I've never sat on a jury, but I've heard that from those who have, that literally they're over here taking notes, not just on the case, but, oh, did you see how he was fighting with co-counsel? Or did you see how the judge yelled at her? Or, all of these other little things the jury is watching and taking note of. One thing that I always used to train my prosecutors on was the way you treat the courtroom staff is really important, because the jurors notice if you're talking very disrespectfully to the clerk or the court clerk or things like that. And again, they're like, if you're that crappy of a person that you're treating people with disrespect, are you just stitching up somebody just because, right? And that starts to leave jurors to go down places you don't really want them to. So I think all of those things are important to consider.
Yeah, and I think there's one other part to that, Melba, and that is, to me, the biggest impression I always made was actually in jury selection, because there are so many attorneys that are so awful at jury selection. And, they say things like, we want to be respectful of your time. And then they ask the same damn question 9 times to the same person. Or they are trying to be a comedian and tell stories, or they're doing things objectionable. So from me, I always, as the government, the state, I always wanted to have everything perfectly together. I wanted to be succinct. I wanted to be serious. I would never apologize to a prospective venire for asking them questions. I would tell them, ladies and gentlemen, I understand that those pews are not comfortable. Those of you selected are coming here to first class with cushioned seats that move. But this is an important process, and it's going to be boring at times. We promise that everything we ask has a reason, but please do not underestimate the importance of these questions. I think that so many times you see prosecutors that are aloof. Or
by the way, Ryan, that is the bus photo, and that is,
like I said,
pretty damn good.
Crystal clear. Yeah. Bus company not trying to get sued. Like,
wonder what's in that backpack. Ryan, is it part of the law to convict based on eyes? Because I'm convicting this guy immediately. Is that allowed, or you're not allowed to just convict?
Well, but look, you're playing with every tool in the toolbox. If I've got a guy who looks angry, who looks dangerous, I'm going through my crime scene photos. I'm going through these stills. I want to pick a still. That camera's going 24 frames per second. I want to put the frame that makes him look the meanest and nastiest. If I'm if I'm using as horrible as it is, if I'm using an autopsy photo, I may want to use an autopsy photo that's not clean, because as a prosecutor, I want to convey how horrible this is. Now, likewise, as a defense attorney, now I don't want those things. I'm fighting these things pre-trial because they're unfairly and unduly prejudicial. But to Melba's point earlier about style, let us not be mistaken. This is theater, and it's broadcast online, and thousands of people follow these things on a daily basis. And unless you are the perfect professorial attorney, like a Barry Scheck, go watch Barry Scheck during O.J. Simpson. That was just methodical. If you're not that way, you do got to put on a show. And unfortunately, most lawyers, especially when they have a TV camera in their courtroom, think that everything they say is brilliant and eloquent and talk 80% more than they really should.
Sometimes silence is golden.
Mm-hmm.
Sometimes it is. Hey, Jimmy McNutty's in the chat tonight. He was at the OJ trial for part of it. Tell us what you think of Barry Scheck. I'll have to go back and watch that. I wasn't, when I watched that, I was a young man, and I was not really paying attention to those things. But yeah, he's, I guess, when it comes to, tying DNA evidence, he's kind of the GOAT. But I'll have to go back and watch his style there. Sade's favorite color, Copper Horse, our mod out of the great state of New Jersey. She is letting us know that Sade's favorite color was pink. John Tompkins seems to have disappeared. We'll see what happens if he reappears, but we will not call the police yet, but eventually. COE, can I let me try to bring this up. This is a clip from openings today of the defense. Here we go. This is Anthony Cotton, the defense attorney. And I can't do it. So COE, can you bring that up? Stand by. Stand by. In news, you get to wear a little earpiece, and they tell you what's going on. Not here. All right, here we go.
State began by using the phrase common sense. You heard it yesterday during jury selection, and you heard it again today in the state's opening. And they're using the phrase common sense because they want you to ignore the mountain of reasonable doubt that exists in this case. I want to start by telling you guys that much of what Mr. Vance Curzan just talked to you about, we don't dispute. So a lot of this trial isn't in dispute. The timeline, the fact that Max met Sade, Max had met her, went on a date with her, that they went to the Twisted Fisherman, that they went to Duke's.
COE, hold up for a second.
That night, that they went back to Max's house.
So I don't want to be critical, Ryan, but number one, I guess everyone's style is different. I guess you do need some notes. It's just like he seems, even with his body language here, like he's not in command, like he's not in control. He's got kind of a almost like a meek demeanor here. And this is a guy who you've got to defend from going to prison for the rest of his life and then some, if he's convicted. And I don't know if the death penalty exists in Wisconsin, but yeah. So I don't know. He just doesn't seem, Ryan, to me, to be a guy, a typical, I don't know, a typical personality of a defense attorney that I would picture in my head. Doesn't seem to be, I guess, a vigorous defense just from the get-go is what I'm seeing.
Well, this is a trap, Joel, because in my next high-profile case, you're going to do the same thing, I know. So I'm going to tread carefully here. But
I would never.
So I think there's a couple basic things. One, that's a lot of notes. And being a criminal defense attorney in a violent case, especially a homicide case, you have to build a connection. So for me, that lectern is a barrier. It's a barrier between me personalizing with a jury. Being able to use just little things, going to the right of the lectern so that my body is open to my client now, being able to talk about my client, not being scared to use his name, not being scared to talk about him. I think when you look at this from a stylistic standpoint, I agree with you. Tone matters, pace matters, pausing matters. Being able to go out front by that microphone with the purple cord there, I want to talk about reasonable doubt right there, right in front of them. I want to focus on me. I want to deflect my attention from the prosecutor, from the galley, from everybody else. I want to be center stage. And on that point, I want to talk about and go over the top about, there's a Mount Everest of reasonable doubt here. And then I want to shut up for 3 seconds. I want to walk back to that lectern. I want to look at my note, even if I don't care what's on that paper, because I want that to marinate into the jury's mind as I then start being methodical and going about my notes or the timeline or wherever else he wants to take his open.
Yeah.
And I would say too that having too many notes is also crippling. You should maybe you should be in command of the facts and just have an outline. Because if you're trying to read, if you have all these notes, you're going to be tempted to read. And if you're reading, your face is down and you're not looking at the jury and you're not connecting with them. So you should have like a sketch of what you're going to say. And then you talk about XYZ. Then, like Ryan says, you do the pregnant pause. You go back over to the podium. You look at the next couple of lines. Then you come back around, deliver a few more hits, and you come back, and you have to basically use the entire courtroom as your playground. Like, I would just wear out the carpet because 1 minute you're at the jury, another minute as a prosecutor, you're in front of the defendant pointing and being like, this is the person. Another moment you're pointing towards the judge and, really, again, educating people on the roles of everybody in the courtroom and in a low key way. Like, the judge is going to make some rulings on things and that sort of thing. You have to make yourself seem like you're the authority in that courtroom. And if you can't do that, jury's not going to respect you, and unfortunately, your case may be sunk.
Well, and I think there's one other point on defense attorneys. Those of us who practice high-level criminal defense are very blessed to have great clients and can earn a good living. A client pays me almost a year of a prosecutor's salary to not need notes, to be able to be rehearsed. I'm videotaping my opening. I'm giving that opening 10, 15, 20 times before we ever get to court. Mm-hmm. Now, the prosecutor's got 20 to 40 homicide cases. I used to do trials back to back as a homicide prosecutor, where it was basically the same case, just insert a different address and different names of parties. So from the defense side, I do think that jurors expect more polish from a defense attorney. Yeah. And if you can come in and give a 20-minute succinct opening without even looking, what that's telling a juror is, we've come to play, we're not giving in on anything. And it sends a message to the prosecutor, you better have your A game.
Yeah. This is absolutely fascinating. But Melba, should I go home depressed tonight knowing that the criminal justice system is really about theater and not about justice? That's what bums me out about all this, because everyone I talk to, and you're all trained, everyone's trained slightly differently, but you all go to law school, and it's fascinating to hear this. It's also, for me, it's fascinating because some of the stuff Ryan just said, not to harp on this, but it's so similar to presenting, on the news. Like, I remember when I first got my first day at Fox News, there was just really they had me on a roof, and it was minus 800 degrees and the wind's blowing, and I had some stuff on my notes, and the notes go blowing off the rooftop, and now I'm stuck, and I just remember, oh crap, I got to just go, and and just go. And it worked out. But there is you, as a reporter, you always want to cling to your notes too. But a good reporter, the same as a good defense attorney per Ryan Vescio, has to be in command of the story, has to, grab onto it and tell it like they own it, all these things. But I'm just a reporter. You guys are saving people their lives from going to prison for the rest of their lives, or convicting people that should be. So should I be more concerned that this is more theater than, I don't know, maybe facts and evidence? I don't know.
Well, this is going to be my closing comment for tonight. I will say that it's more probably equal parts theater and evidence. Mm-hmm. I think that, listen, if the evidence has the defendant dead to rights, the jurors can hate both parties in terms of the defense attorney, the prosecutor, all day long. Doesn't matter. If the prosecutor has defendant dead to rights, he's going to get convicted. They're going to get convicted, right? If the defense has an amazing case, at the end of the day, the person's going to be found not guilty. So I don't think that style is going to overcome facts necessarily, but it can give a nudge in one direction or the other. I wouldn't say a style is completely definitive, but it can be that slight deciding factor, especially if it's one of those cases where it's 50-50, like, you know, the evidence is decent, but the defense has some really good arguments why the person may be not guilty. Then it comes down to, who do I believe more? Who do I find more credible, the prosecution or the defense?
Yeah. By the way, the journey to justice. I was at the trial today. Let us know. Was it crowded in there? Was it packed? You know, and someone wanted to know if Max Anderson had any family there. We do not have to stand for the judge or jury in this courtroom. That's interesting. I've never. Different courtrooms operate differently, and I never knew that. And I found out in Connecticut when we covered Michelle Troconis, they don't even have opening statements, which is like the weirdest thing to me. But let's COE. I didn't mean to cut that off so quickly. Let's listen to a couple more minutes. This is Anthony Cotton, the defense attorney for Max Anderson, at opening statements today.
Hey, carry on.
None of that is in dispute. The fact that body parts wash up at Warrimont Park, the fact that body parts are found at 31st and Galena, the fact that those body parts belong to Sade, nobody here is disputing any of that. It's horrible what happened to Sade. It's horrible. Nobody deserved that. And what the state wants you to do is use the emotion of that, along with this phrase like common sense, and use that emotion to convict Mr. Anderson. But I implore you in this trial, your most important job as jurors is to study the evidence closely that's introduced by the district attorney's office. We have no burden of proof. Max is not required to prove anything. The entire burden lies here and rests here entirely on the district attorney's office. And it's the highest burden in the land to marshal together, to put together enough evidence to bring to you to show that Max killed Sade and that he committed those other crimes. There are a few pieces of evidence that the state will rely heavily on. Max near the scene of the car, Max when it's burning, Max being the last person to go on a date with Sade. And that's frankly why law enforcement zeroed in on Max. You are going to hear that the amount of law enforcement resources that were spent in this case by the Sheriff's Department, the Milwaukee Police Department, the FBI, the amount of resources that were spent on this case, I think is probably unparalleled in Milwaukee history. The amount of money and time and effort that was put into
COE, hold that for a second.
Video evidence to searching Max.
So I was on the bike at the gym when I heard this, and this caught my attention, Ryan, because this is a woman who was literally decapitated and dismembered, and this guy's up there, I don't know, griping about the fact that too much money is spent on resources. You have to be really careful with what you say and how you say, because I, as a basically what I consider to be an somewhat impartial observer, I said to myself, why the hell would he even mention this? You know, why say that? Because you're going to really rub people the wrong way who wanted answers and still want answers here.
Well, and not good. And here's where my mind went, Joel, was, oh my gosh, if this was the most highly investigated homicide in Milwaukee, and that guy is sitting there in a plaid shirt and a t-shirt underneath, well, surely the police got it right, because look, this was the biggest investigation they ever did. And you know, I think that, so in this particular type of situation, as a defense attorney, I don't ever want to go back and talk about what the prosecutor just talked about, unless it's something in a brief mention. So, you know, if the point he's trying to make is they did all of this and they zeroed in, it is, you're going to hear about an extensive investigation that failed to identify these questions that establish reasonable doubt. I mean, I think if you ping it real quick and go, that's great. But right now, I'm reading this as a commercial for the state.
Yeah, 100%. John's back. John, we got you muted because audio's a little funky. But COE, let's play it another couple minutes, and then we'll get some closure on this. I think Melba had a bounce. We're playing some rotating attorneys tonight, but a little bit more. And John, I'm sure you're aware, but this is Anthony Cotton, the defense attorney for this defendant, Maxwell Anderson. Go ahead, COE.
Maxwell's home, to interviewing coworkers, interviewing people that might know him, an immense investigation. And the state knows that there are serious holes in their case. They know it. They know that there's reasonable doubt, and that's why they're coming at you with this phrase like common sense. So let's talk about that. There is absolutely no reason for Max to commit a crime like this. What you're going to hear in this trial is that Max and Sade lined up a date together like any couple of youngsters do, and they lined up a date at Twisted Fisherman. This is a place that Max used to work. You'll hear that they went there, they had dinner, and it was an ordinary evening. From Twisted Fisherman, as the state just told you, they went to Duke's. This is another place where Max is known. There was no secret place that Max took Sade that night, nowhere that anybody wouldn't have known him or recognized him. These are former places he worked and coworkers that he interacted with. And what I didn't hear was the theory of why Max did this, how Max did this. But I think what I heard in opening just now is that Max must have done this at his home. That seems to be the theory. Max brought Sade back to his home and killed her. Why? It's a normal date. You'll see them let camera footage leaving Duke's. You'll see them, Sade driving back to his place. You'll see them going there. In this timeline you were just given, I don't know how many witnesses they're going to call throughout this trial to put in this video or that video, but one thing you'll see throughout this is that we don't dispute any of that timeline, that they went out together and went back to Max's house, but that doesn't mean he killed her. How did he do it, and why did he do it? Why would he ever do something like that? If Max killed Sade in his home, if it happened in that location, as I think they're offering to you, there would be a mountain of DNA evidence. There would be blood. There would be some form of DNA. And I listened carefully when I heard the state's opening, because yes, it's gruesome. Yes, it's horrible. Nobody deserves it. But what was glaringly missing from what I heard was any discussion about DNA evidence. We have a crime lab in the state, law enforcement agencies that are tasked with collecting evidence from locations. I believe the theory that you're being offered today is that Sade was killed at Maxwell's house. What you'll hear about Max's house, I want to tell you a couple of things they didn't tell you. One is that the house is a duplex, upper and lower. There's a stairwell you can enter through the side of the home. If you go in the stairwell, there is a lower unit that has a tenant, if you will, who lives on the lower level. His name is Pete Warmington. You'll hear his testimony in this trial.
All right. That's the neighbor. John Tompkins, while you were out of pocket for a few minutes, we were talking just about style. And this guy, although he's apparently a pretty well-known criminal defense attorney in this neck of the woods, he didn't ignite any passion in me. I'll tell you that. He just seems to have a bit of a flat affect. He's checking his notes a lot. He's stumbling over words. It's easy to criticize, trust me, because I get criticized all the time, and I love nothing I love more than criticizing other news people, because I do it incessantly. But John, what do you make of Anthony Cotton's performance so far?
Well, I'll speak about style and content,
Mm-hmm.
and I will relate one. Really, I'll tell you the very best continuing legal education program I attended was at the Palmer House in Chicago, and it was run by the people who produce the skits for Second City TV. And they told us how to do narratives and how to treat the area in front of the jury box the way an actor would treat the stage to the audience. Not to make it into a fictional play of the trial, but actors know how to communicate with their whole body. Actors know how to communicate with their facial expressions. And that is a form of communications attorneys need to know. So I noticed that there's a podium. I don't know if that judge requires the lawyers to stand at the podium. When I have a judge who does that, I keep one hand on the podium and walk around it. I never put notes on a podium. So stylistically, I would have liked to see him using just his body, his hands, and his facial expressions to emphasize his points. Different jurors pick up different communication keys. You have got to communicate on all levels if you have 12 or 15 people sitting in a box listening to you, period. So stylistically, I think he could have done better, but he might have been limited by having to stay at the podium. That might be a rule in that court. Content-wise, I'm going to echo the earlier comments. One of my pet peeves is hearing the defense attorney get up and repeat the state's points. They said it. You're up there to take their case apart. And
by the way, I'm sorry to interrupt again, but I am interrupting again. Yeah. He also, not only does he do that, but he says, if I heard correctly, so he's putting doubt in the juror's mind that he's even right about what he's questioning the government about. So it's like a double negative that does not turn into a positive. Go ahead.
Exactly. And so you've got to go up and state your case, give your narrative, try to get some things in front of the jury that they can connect with your client on. This was a normal date. Any of you could have gone on this date. You'll see what the evidence is going to show you is that he wasn't acting strangely. He was around people who knew him. They never said he acted strangely. When they were interviewed later, they didn't say he was acting strange or nervous or that he was carrying something that looked like it might be dangerous. He wasn't playing with the drinks. And really emphasize what your narrative is going to be. Try to connect your client to this jury. Try to find some people who are nodding and going along with that so you can speak to them later with questions and cross-examination. And be assertive and be confident and say what the evidence will show, but more importantly, say what the evidence will not show. Here's what, if you're going to start talking about what the state didn't say, what you're going to have to connect that to is what the state didn't prove. I would like to have seen more content about 250 witnesses. That is almost an inherent sign of weakness in a case. If you don't have strong facts, my experience is prosecutors will try to make up for that with the sheer amount of evidence that they put in front of the jury. And my counter to that is an opening statement saying you're going to hear a lot of people who have no idea what happened.
Yeah.
They're going to put a guy up here who says I strung yellow tape around and stood there and wrote names down.
Yeah. And John, real quick. So we're looking at a photo here
right.
from the bus, and so he gets off this bus and it fits the timeline perfectly in the wee hours of the morning on April 2nd, and doesn't take a detective to see that it's very likely the same person. This right here could be the most damning piece of evidence that there is in this case. You're the defense attorney. What are you doing right now to counter this?
Well, I'm talking to the people on the bus. I'm asking if anybody smelled gasoline on him. I'm pointing out that there is no blood anywhere on this person. There are no indications that he is stressed or that he is trying to hide his face. The hood is open to his face. There's no mask on his face. If they recovered that backpack in the search of his apartment, I'm pointing out that they're not finding any evidence connected to the crime in that backpack. And I want to know what's in that backpack because it might explain why he's out there. But you've got to again point out what that photo doesn't prove. It proves that he is in a place that is close by. But is this what you would expect to see from someone who just walked away from a burning car? Did anyone in that bus say they smelled smoke or gasoline on him? This is within less than an hour after he douses it with gasoline. And there are gasoline containers back at his apartment, if I'm not mistaken. Well, they're not with him here. So did he drive across town in a car doused with gasoline and nobody noticed he smelled like that when he got on the bus? You're just trying to show some inconsistencies.
Well, and look, he's got no abrasions on his hands. He's got no soot on him. He doesn't have black soot on his hands. He doesn't have white sort of soot on the dark jacket. Doesn't have any facial injuries. But this is a guy who supposedly dismembered somebody within the last hour or two. So I don't want to say the video cuts both ways, but to John's point, if I'm a prosecutor, I don't want to sell my case on this. I want to show it. I want to hit it that he's on this bus and the bus was at this area at this time, and then I want to move on.
Yeah. This is absolutely fascinating to me. Ryan, I got a question for you. What if you're having a conversation with your client and something slips from his mouth that shouldn't? What is your obligation? Let's say he reveals something.
Well, the attorney-client privilege is sacrosanct. And unless he's telling me about a crime that he's about to commit, that statement gets buried at the bottom of the ocean. The only other situation where this can come up from time to time is if you have a client who has made certain disclosures and then tells you that they're going to take a witness stand, be sworn in under oath, and then testify differently from what they've previously told you. Now, I'm an officer of the court and I can't allow that fraud to be perpetuated. And there are certain things that defense attorneys can do so as to not incriminate their client to a jury or the court, but also not assist them in giving knowing false testimony.
There you go. This is La Mesa is basically saying she knew someone that was trained in, I don't know, fires and they wouldn't smell necessarily. So that's interesting. Ryan, back to you. And this is a trigger warning. So I want to give everyone a chance to earmuff themselves because what I'm about to say is extremely disturbing. 5, 4, 3, 2, 1. So Ryan, in this particular case, it's and I don't mean to be funny at all. It's like it's not a it's part of a body here. So the head was never located. What we learned too is that her right breast was removed surgically, and that's never been discovered. Her torso floated up from Lake Michigan, which is near this park that we heard about in this allegedly private beach that he knew about. Even at the dump site where the leg is found, there's no blood, no weapons, nothing. I guess my question buried in all this is there's incredibly difficult and graphic things that this jury is going to have to see. How do you toe that line as a prosecutor and as a defense attorney? Because you don't want to, particularly as a prosecutor, though, you don't want to turn them off to the case or have them become angry at you because you're now showing them a woman who's literally had her breast removed. It's not something that people want to see. How do you deal with that?
Well, and to expound on your trigger warning here.
Yeah.
One of the things is this, in this type of case, I want to look for, and I want to highlight, what are the other injuries? Are there contusions? Are there stab wounds? Are there broken bones? So obviously everybody gravitates to dismemberment, but those pieces tell a huge story. Are they clean cuts? Or are there indications that joints are broken? What other sorts of injuries may or may not be there? The hands, extremely important. And knowing that I don't have a scene with a proposed scene with a lot of blood, don't have a vehicle where blood is recovered, is awful and as gruesome as it is. I want to try to figure out any way possible as a prosecutor to explain this as a post-mortem after death process. And the reason why I say that is from a forensic pathology standpoint, you're going to get more blood or less blood depending upon when those injuries are in relative to the actual time of death, even though you can hardly ever prove that. A good forensic pathologist can talk about pre-mortem, at the time of death or post-mortem type of injuries. So as a prosecutor, I may want to point that out if the science is leading me there. As a defense attorney, I can't keep the state from putting that type of information up. What I can do, though, is I can try to spin it on the state to say the government needs to show you the most gruesome photos imaginable because they're showing you those photos instead of evidence that establishes guilt beyond a reasonable doubt. That to me is really the only way that you could turn horrific photos, not even to your advantage, but sort of neutralize the damage that they have to your client.
By the way, some new people in the chat. Welcome to everybody. We do a live nightly show like this every evening, except for Friday. We do it in the afternoon. And we do some trial coverage as well. And we do some Diddy updates that I've been doing here. Not one, but a few people have commented that maybe this guy is a skilled hunter and not, doesn't necessarily have a background, or a butcher, something along those lines, which would be straight out of a horror movie. And I guess some of these details are to come. For those who do not know, John Tompkins is the defender. You see it there. He's live in Indianapolis. He came to us during the Delphi trial, a very savvy criminal defense attorney. John, just want to get your final thoughts here. Flora Paris, what a name, Paris. She asked, and I don't know if you know, with a body in this sort of shape, can a toxicology report even be done? Can we find out if she was drugged, before she was killed?
They can do toxicology. What it's going to show is a big question. So, and this relates back to no blood, the surgical nature of these wounds. It's, and I would go back and even some of the people who commented on the gasoline and the smell, and if you're trained in a certain way, you might be able to avoid that. Well, now you're digging into that hole of where's that training? Is there are any of these 250 witnesses going to establish that he had that training, that he was a good hunter, that he knew how to dismember deer or other wild game that he had? And you get into the skill set and the tools that are necessary. If I would like to know from the recovered leg, was there blood still in that limb? Because if there wasn't, you get in with the medical examiner, it's a whole different job removing blood from a corpse. They put them on drainage tables. That is a skill that only highly trained people know how to do. Sure, hunters can cut the neck of a deer and drain the blood out quickly, but that's not what's going on with the human body. If there's blood in that leg, they can do toxicology on the blood. Vitreous humor of the eye is one of the common fluids they test for toxicology. However, obviously, and however gruesome it is, they're not going to be able to test that fluid in this case. So you find out, and if there is no blood to test, that incorporates into the defense of means and opportunity. Where we know the means, does he have the tools to perform this task? Because you do not do this with kitchen knives, and you do not do it with saws. Does he have the ability to extract blood from a body? Because it doesn't all flow out normally. So if there's no blood in that leg, how did it get removed? And those are some of the questions you try to incorporate into an overall defense. The means seem to be beyond a layperson or a person of his skill and background.
Yeah. This is like Hannibal Lecter's type stuff here. But John, a final question for you, then we'll get final thoughts from Ryan. The defense basically came out, and one of the things they said, if you listen to the openings a little more, said, look, this guy has no motive to do this. He was on a date. He didn't try to hide himself. He did no Google searches that we know of, trying to figure this out, which we talked about earlier. How important is it for the prosecution, from your perspective, John, as a defense attorney, to articulate, they don't have to prove motive, I know, but how important is it for them to have to articulate why he would have done this?
Well, the juror is going to be told over and over and over that the state doesn't have to prove motive. And it's a dangerous line to walk in opening statement to talk about they're not going to prove motive, because first of all, you're not making a point. You're not talking about anything the evidence has to prove. And second, you might be opening a door, because now the prosecutor can approach the judge and say, hey, judge, he just opened the door to anger, losing his temper. There are prior incidents with him, prior offenses that he's committed where he lost his temper and went off the deep end with relatives and friends. And, he just allowed us to come in and explain how this could have happened with no motive. So that was a risky strategy, and you don't really get any points by saying they don't have a motive. He didn't have a reason to do it, because all they have to do is give him and say, we don't have to give you a motive. And you're taking time away. I'm going to go back to it. You're taking time away from your narrative. Your entire opening statement is to set the table, is to give key words and phrases to the jury that you will then repeat in your questions to their key witnesses. So the jury's like, oh, he said that to us before. And they're tying your narrative. And if you're not doing that, you are not preparing that jury for the trial, and you're not keying on the fact that while you may have spent months preparing for this trial, this jury is going to get 8, 16, 20 hours. That's all they get. They don't know nearly as much as you do, and you have got to set that table, give them the key words and phrases that you're going to repeat in your cross-examinations, so they will key in that precious small amount of time that they have to figure out in their minds whether the state has proven the case or not.
Very, very interesting stuff. Ryan Vestio, I had a thought in terms of presentation, and give me a straight answer here. Don't be humble. But the fact that you are around 6'6", does that play to your advantage? I mean, that's got to have an advantage, or be an advantage for you. I was joking. I actually did. I did this. I was a reporter on the floor of the New York Stock Exchange, and I would interview these CEOs, and they were all like 6'3" white dudes. And they were, and I'd always get mad because, I'm 5'10", 5'11". But do you have an unfair advantage in the courtroom because of your height and bringing in that presence?
Well, what's good about it's bad about it. So yes, it is easier for me to be the center of attention because, as my kids point out constantly, I take up a lot of surface area. But the downside to it, and I learned this early in my career, came in 2 instances. When I would cross-examine and go too close to a witness stand, especially with a smaller witness, it looked like I was beating them up. And with a jury, I learned early in my career, if I get too close to that jury box, sometimes it can be a little too intimidating to where they're not focusing on what I say. But I would rather be 6'6" than 5'6", so in my profession.
I would hope John's not 5'6", but I'm
Not
with you.
5'8".
I'm sorry about 5'8's a big difference from 5'6".
That's true.
But look, Muggsy Bogues could dunk. So Ryan Vestio, for those who do not know, was a homicide prosecutor in Orange County, which is the Orlando area, and now does defense and criminal defense work. And Ryan, my final question to you, I mean, it's a partial, which is very sad and sick to say, it's a partial body case. But these days, does this matter with digital forensics and the evidence that they're going to be able to, and these photos we saw from the bus, that they're going to be able to bring into evidence during this trial? How important or unimportant is a body these days? Your final thoughts?
Well, I mean, candidly, a body is less important now than it was 20 years ago when I started. So the body obviously is an extremely important piece in a homicide. And in this particular case, having not seen the autopsy report, I don't know for certain, but sometimes there could be a difficulty in determining what the cause of death actually was at the end of the day. But it is a piece of the puzzle, and it's something that the state is going to use to its advantage to argue about the brutality of this crime with all those other evidence items that you discussed. It's also going to be a benefit to the defense, who's going to be able to walk a fine line, but potentially point out that we don't know exactly what did happen. So I think it's something that you mentioned earlier, and it was the intersection between theater and justice. And obviously, justice means something different to every person who's in the courtroom. But at the end of the day, I expect what you're going to see is two sides vigorously, although melodically, arguing their points to support their theory. And ultimately, 12 jurors are going to decide what justice looks like in this case.
Yeah. You're looking at 19-year-old Sade Robinson, who will never see another birthday because her life was taken in the most horrific of ways. We got to get justice for her. The evidence right now looks a bit overwhelming against Maxwell Anderson. We'll see how it plays out. If you do want us to cover this trial, send us an email, survivingthesurvivor@gmail.com. This is a community. It's a big family here, so I want to see if you guys are interested in having us air it. It'll go through next week. We could air it during the day and do some more shows on this as well. Wisconsin has had some very, very eyebrow-raising crimes, red rums, etc. Yes, it has. By the way, I've mentioned this before. Ryan Vesio, I know a reporter in Tucson, Arizona, who is 7'2",
Ooh.
and he's 7'2" and more than a vertical direct. He's a big, big guy, and he'll interview sheriffs in a 2-shot, and I just can't get over what I'm looking at. They look like toddlers. So every once in a while on my Instagram page, I will post a photo. Maybe I'll put one up there tonight. It's at Surviving the Survivor on Instagram. We put the show times on Twitter at Podcast STX, at Podcast STS. It is now X, not Twitter. And yeah, follow us there. Give us a like. Subscribe if you enjoyed the show or appreciate the content. We'll be back tomorrow with Diddy and possibly this trial. So again, follow me there for all the latest information. Ryan, thank you to you. John Tompkins, thank you to you. And Melba Pearson for being here. And we'll pick it back up tomorrow. Love you, America. Love you, Orlando. Love you, Indianapolis, Indiana. Woo. Milwaukee, Wisconsin. And justice for Sade Robinson and her family.